A pleasant afternoon and a warm welcome to everyone joining us here today. I am Anna Kimpo and I will be facilitating this afternoon's event. Welcome to the inaugural activity of the Asian Society of International Law's International Criminal Law Interest Group, featuring a lecture on the ICL dimensions of the Ukraine-Russia situation, to be delivered by Judge Raul Pangalangan, former judge of the International Criminal Court. Today, the UP Institute of International Legal Studies ICL program also launches its ICL blog, a new platform for scholars and ICL researchers to share their ideas and commentaries on burning ICL issues. I would like to acknowledge the presence of Professor Anthony Angie, Professor of Law at the National University of Singapore and Secretary General of the Asian Society of International Law. I would also like to acknowledge the presence of the faculty members of the UP College of Law, the lawyers of the Institute of International Legal Studies, and the colleagues from the AsianSIL ICL interest group. Before we begin, I would like to go through some preliminary matters. In case of technical difficulties, please try closing all bandwidth-consuming applications and browsers. I would like to request that you keep your microphones on mute to avoid background noise. Throughout this afternoon's lecture, we invite you to contribute to the discussion by posting your questions for Judge Pangalangan in our Q&A chat box. We are also streaming this event live in the UP College of Law Facebook and YouTube. To begin this event, it is my distinct honor to introduce the co-convener of the AsianSIL ICL Interest Group, Dr. Chia, for her opening remarks. Dr. Chia is an associate professor of law at the National University of Singapore. Her research work is in the area of international and comparative criminal law, transitional justice, and human rights. Let us welcome Dr. Chia for her opening remarks.
Thank you very much, Anna. Dear participants, it is my pleasure to welcome everyone to this event, which marks the launch of the International Criminal Law blog and is the first event of the Asian Society of International Law's International Criminal Law Interest Group, featuring the lecture of former International Criminal Court Judge Raul Pangalangan. This event is co-presented by the UP Institute of International Legal Studies and the Asian Society of International Law's International Criminal Law Interest Group, which I have the honor of co-convening with Professor Ronald Cassis. While some have observed that international law has seemed irrelevant in the face of the Ukraine conflict, I would argue that never more has it been more important to strengthen and enforce international law. This is not to say that all is well. All is clearly not well, and there's clearly a need for critical revisiting and transformation of international laws, institutions, and rules. Initiatives and spaces such as the blog launched today, as well as associations such as the Asian Society of International Law, can play an important role in facilitating such critical debate and reflection on the shortcomings and gaps in international law and on how it can be transformed. As co-convener of the Asian Society of International Law's International Criminal Law Interest Group, I hope that this group and its activities can also serve to stimulate critical debate on international law. This interest group is open to all members of the Asian Society of International Law, and I want to take this opportunity to encourage members to sign up to this group if they have an interest in international criminal law and its associated fields. The interest group aims to foster inclusive discussions and collaboration on international criminal law, broadly understood, among members of the Asian Society of International Law, as well as the larger international law community. We hope that this lecture of Judge Raul Pangalangan will stimulate broader debates among members on international criminal law's role in the Ukraine conflict, as well as its role in maintaining peace and addressing conflicts in the region. I also hope that the interest group, beyond promoting international criminal law interest and debate, will help form and cultivate both informal and formal connections among international law academics, practitioners, and students in the Asian region. Based on my own experience in academia, Formal and informal collaborative connections are essential to one's growth and development as an international law practitioner or scholar. This is clear when you take a cursory look at the acknowledgements set out in any scholarly journal or book. Everyone is citing the people that they have benefited from. So no one is really a solo actor in international law. This is also, based on my observations, those coming from established institutions or better resourced societies find it easier to build such connections. Close connections are important, especially for the encouragement and support one needs in different stages of your international law career. However, equally important are more distant and looser connections, such as those who are not in your direct field or working directly on your topic. People you can reach out to for information about a new international law job, on how to get the application done. People you can reach out to for international law information about a particular jurisdiction. Such connections can go quite a way to overcoming information and resource asymmetries between better resource and less resource societies. I believe that the Asian Society of International Law, by encouraging inclusive initiatives such as the establishment of interest groups, can contribute to the building of such connections that are essential to the building and development of international capacity in the region. With that, I would like to bring to a close my opening comments, thanking all who took time off to participate in this event, co-organized by the Asian Society of International Law's International Criminal Law Interest Group and UP's Institute of International Legal Studies. I trust that all of us, including myself, will learn much from Judge Raul Pangalangan's lecture. Thank you.
Thank you very much, Dr. Chia. Now, it is my distinct honor to introduce Judge Raul C. Pangalangan, a former judge of the International Criminal Court. He has resumed his post as Professor of Law at the University of the Philippines, where he also served as Law Dean. He has taught international law at Harvard Law School as visiting professor and has served as Director of Studies and later lecturer at the Hague Academy of International Law. He has also held visiting appointments at the Hong Kong and Melbourne universities and has lectured at the Salzburg Seminar on International Law, Humanitarian Law, and Human Rights, and as keynote at the Irish Center for Human Rights, the Thessaloniki Institute of International Public Law, and Waseda University in Japan. He is currently a member of the Permanent Court of Arbitration at The Hague and a judge of the Asian Development Bank Administrative Tribunal in Manila. He sits in the Governing Council of the Asian Society of International Law. He received his AB cum laude and LLB from the University of the Philippines and his LLM and SJD from Harvard Law School. He is the only Filipino who holds a diploma from the Hague University of International Law. We welcome Judge Raul C. Pangalangan, who will give his presentation on the international criminal law aspects of the Ukraine-Russia conflict.
Thank you so much, Anna, for the very kind introduction. Before anything else, I wish to acknowledge the presence of Professor Tony Angie, the founder of TRILA, Teaching and Research in International Law in Asia, a path-breaking initiative that will change the direction of the discipline within our region. I also wish to congratulate Professors Rommel Cassis and Chia Wheeling, the co-conveners of the interest group. I am happy that Professor Wheeling has shown us how exciting the work ahead of us in the interest group is, by bringing together scholars in Asia and on Asia, working on international criminal law issues. I like the language of Wheeling that the interest group will foster connections to build up the capacities in this field in Asia. I think it takes this interest group to bring together kindred souls to work together and to build on each other's strengths. On the topic at hand, Wheeling is correct. We face what I consider the biggest threat to the discipline of international law today. I mean, the Russian invasion of Ukraine is a disaster in many respects. But for us as serious scholars of international law, it shakes the discipline to its foundations. It is the unabashed invasion of a sovereign state by another sovereign state with the thinnest legal veneer. It undermines the post-World War II international legal order founded on the prohibition of the use of force against the territorial integrity and political independence of. What I propose to do this morning is to use the Ukraine situation to reflect on the place of ICL, of international criminal law, vis-a-vis general public international law, and to look at both the strengths and the limits of ICL in dealing with atrocity situations. So from both ends, strengths and weaknesses. And so let me just start briefly with the facts. And I will, forgive me if I will skip the legalese and just resort to shorthand terms to get things moving faster. Let's look at the ICC response. Russia invaded Ukraine on February 24, a Thursday. By Friday, the ICC prosecutor already issued his statement, acknowledging at the outset neither Ukraine nor Russia were members of the ICC, neither state had signed the Rome Statute, but saying that the Ukraine situation was within his remit, because the Rome Statute allows ad hoc submission to ICC jurisdiction, and Ukraine has invoked what we call the Article 12, Paragraph 3 option of ad hoc submission, arising from the first Russian incursion into Ukraine and the annexation of Crimea. And the prosecutor thus relied upon the submission of the second submission to ad hoc jurisdiction filed by Ukraine, and concluded that notwithstanding that neither state was a member of the Rome Statute, he had jurisdiction to look into the situation, except, and this is most significant, he says he can investigate war crimes, he can investigate crimes against humanity, but not the crime of aggression. Because again, the way by which the court acquires jurisdiction over the crime of aggressive war is distinct from that of the other core crimes under the Rome Statute, because for the crime of aggression, it requires, in effect, that both states involved be members of the Rome Statute. And my last point on this first statement by the prosecutor, he also eventually, by Monday of that, following the invasion, he issued he said, I have looked at the record and I'm moving forward to ask for permission from the pretrial chamber of the court to move into the formal investigation stage. And he made a call. He said, however, if there are member states who are minded to refer this case to me, he says that under the rules, he will be able to bypass that stage of asking permission from a pretrial chamber. That was a statement he issued on a Monday, and by Wednesday and Thursday of that week, he got lots of referrals from states parties. By Thursday, 41 states had already made the referral, and therefore clearing the way for him to move into the formal investigation stage, basically saving the court another roughly 6 months of a pretrial chamber proceeding looking into the case. So notice that at this stage, the court has, the ICC prosecutor had moved with unusual dispatch in addressing the situation with admirable speed. Let me proceed to the another entity, the International Court of Justice. Likewise at The Hague. And this time we are dealing not with individual criminal responsibility, as it is before the ICC. We're dealing with state responsibility. So again, the invasion was on a Thursday. By Saturday, Ukraine filed the case before the ICJ, and by Monday, the ICJ already started to issue. It set the case for hearing the Monday after. Again, considering that these judicial institutions move at a glacial pace, this was all very fast. But the interesting part is how Ukraine invoked the jurisdiction of the ICJ. And the answer is it relied upon the compromissory clause of the Genocide Convention. And again, the court set it for hearing, and within less than a month issued its order on provisional measures. Let me proceed to yet another entity, the UN Security Council and the UN General Assembly. As expected, Russia exercised its power as an unelected permanent member of the Security Council and basically vetoed the US-sponsored resolution for the Council to condemn the invasion of Ukraine. But the interesting thing is that the UN General Assembly stepped into the picture invoking a 1950 resolution, the Uniting for Peace resolution, adopted by way back during the Korean War, and when the Security Council couldn't move on a call to stop the aggression by North Korea against South Korea. And invoking that resolution, the General Assembly was able to adopt a resolution the Wednesday following the invasion, calling for the cessation of hostilities and for the withdrawal of Russian troops and of all military units under its command. So let me now proceed to some reflections. One response to all the legal responses was, "Wow, legal institutions are working. We've never seen these institutions working, responding so quickly, responding with such speed. It is good to see them working." That is one response. The other was, well, what do you mean when you say institutions were working? Were you counting the resolutions that they adopted? Maybe you should be counting bodies found in mass graves. Maybe that is the real test to find out if the mechanisms for peace under international law were working. Which brings me then to the difficulties of choosing a judicial or a legal path in dealing with a crisis of this nature. And if you look at the nature of judicial power, it is slow, it is deliberate. Decisions are taken on a normative basis, and a decision on a concrete set of facts will establish precedent, which will be invoked in the future. In other words, courts in effect lay down rules that will be applied in future cases by faceless parties and one has to make sure that a rule which looks just and fair in this situation will most probably be just and fair as well in those future cases. And so the classic description is that of Benjamin Cardozo on the nature of judicial power, that we must protect courts against, and here I quote, the assaults of opportunism, the expediency of the passing hour, the erosion of small encroachments, the scorn and derision of those who have no patience with general principles. So in this way of looking at the way courts work, you can say that, sure, they're slow, but there's a way by which we can make a virtue out of necessity. Or to paraphrase my favorite legal philosopher, Roberto Unger, we anoint lethargy with piety. That's a paraphrase, by the way. The original is anointing power with piety. Okay. Let us look then at the power and limits of international criminal law. The first is this. Notice the limits of its jurisdiction. Had it not been for the ad hoc submission to ICC jurisdiction by Ukraine, the OTP prosecute, the Office of the Prosecutor of the ICC will be completely an outsider to the situation. There's basically nothing that he can do short of a referral by the UN Security Council. That is the only way by which he can overcome that jurisdictional constraint, and the only way that constraint can be overcome is if Russia will desist from exercising its veto power in the Security Council. So that is the most formidable, the search for the jurisdictional nexus, either the nexus of nationality or the nexus of territory, is the first and foremost challenge. Mercifully, in this case, we have satisfied that, that constraint with the ad hoc submission. The next is this: the problem of fair labeling, the problem of calling the crime, of describing the exact crime that was committed. We face that problem, as recognized already by the prosecutor, that even though the crime that was violated, that was committed, was a crime of aggression, prosecutor says he cannot investigate that. Sure, he can investigate war crimes and crimes against humanity, but not aggression. Again, that is how the rules, that is how the jurisdictional rules were drafted. The third is that the process for cases to move forward at the ICC, when they are initiated by the prosecutor on his own, not by a referral from a member state, not by a referral from the UN Security Council, but the prosecutor moving on his own, that power is subject to review by a pretrial chamber, a mechanism to avoid prosecutorial abuse. And in this case, the member states, 41 of them, moved together to enable the prosecutor to bypass that stage and to fast track the investigation. Okay, this problem of fair labeling is not due to the court at all. The most dramatic recent example actually comes from our part of the world. The ICC investigation of the genocide against the Rohingya in Myanmar. And the most relevant part of that analogy is that everyone talks about genocide of the Rohingya committed in Myanmar, but Myanmar is not a member is not a signatory to the Rome Statute, not a member of the ICC. The ICC has no jurisdiction over Myanmar. However, the next door neighbor is Bangladesh. It is a member of the Rome Statute, and the Rohingya minority were actually being driven to cross the border into Bangladesh, and a pretrial chamber of the ICC has given the go signal to the prosecutor to investigate the crimes committed against the Rohingya. But because, again, of those jurisdictional constraints, what the prosecutor will investigate is the crime of deportation and the crime of persecution, not the genocide. Because the crime of deportation, for instance, there are elements of that crime which are committed in the territory of Bangladesh, thus satisfying the territorial nexus. Contrast that to the treatment of this exact same historical episode before the ICJ. The basis of jurisdiction invoked before the ICJ was again the compromissory clause of the Genocide Convention, and over there, they can correctly and accurately characterize the issue as genocide, in contrast to the ICC, which had to act as if it were not dealing with genocide, but solely with deportation and persecution. Compare that again to Ukraine. It is again, if the real crime being committed is aggression, and as stated at the Nuremberg tribunal, the crime which makes all the other crimes possible, which sets the setting for the war crimes and crimes against humanity and possibly genocide possible. In order to invoke the compromissory clause of the Genocide Convention, Ukraine actually had to ask of the ICJ a negative finding. Basically, the typical scenario with the Genocide Convention cases is in Bosnia, for instance, in the Myanmar case, one party goes to the court and says, well, I'm invoking the Geneva Conventions. Your Honors, please issue an order finding that other party guilty of violating the Geneva Convention. In this case, Ukraine is not doing that. What Ukraine is saying, at least so far in its pleadings, is, can you please tell Russia, we're not committing genocide, and therefore if they say that they are invading us because we're committing genocide, they have no basis for doing that. And the other pleads that. And indeed, even if we are committing genocide, the outright invasion is not an authorized, is not a valid countermeasure. So there is that problem of legal characterization. And the other, but notice that this is not the first time this is happening in international criminal law. It happened at, what I will say, the founding of this field at Nuremberg and at the Tokyo War Crimes Tribunal. Today, our recollection of what happened during the World War II, if one speaks about the European theater, it is associated with the Holocaust, with the gas chambers, with the genocide against the Jewish people. If we speak about the theater in the Asia Pacific, we recall the atrocities committed against POWs and against civilians. But if you read those two decisions, they're primarily about the crime of aggression. In other words, what we're facing today, what I call the issue of fair labeling, of discussing exactly the crime that was committed, and the variance between the official legal language, and the actual historical events happened the other way around at the Nuremberg and Tokyo tribunals, whose decisions were mainly about the crime of aggressive war, but which are largely remembered for the genocide and the crimes against humanity and war crimes. Let me proceed to my next point, and I would like to close with this so that we can move on to the Q&A. I go back to the jurisprudential distinction made by HLA Hart between primary rules and secondary rules, between the substantive norms of what is right and what is wrong, and the secondary rules for the enforcement of those rules, the rules about rules. And often ICL is seen simply as yet another enforcement regime. There are the human rights treaties. There are the Geneva Conventions and the additional protocols for IHL, and there is ICL. And the popular attitude is that these are just different ways of enforcing the same thing, and indeed they are, but not just enforcement mechanisms. And I suggest that in choosing the enforcement mechanism, in a way, we actually affect the norms that we are enforcing. And that is why, if one looks at the prospect of applying ICL to the invasion of Ukraine, in contrast, for instance, to the ICJ proceeding, then we must accept the reality that we're dealing with international criminal law. The rules, the procedural rules, typical of fair trial guarantees in jurisdictions all over the world, those rules are loaded in favor of the accused. There is the presumption of innocence enjoyed by the accused. There is the burden of proof by the prosecution, and there is a very high evidentiary standard, proof beyond reasonable doubt. In fact, at this stage, the prosecutor is already moving forward with this investigation. The end result of that investigation will be to identify the persons to be indicted before the court, and of course to identify the charges to be filed. That is a process which will take a while, and in contrast to state responsibility, which will be exercised with a lower quantum of evidence, unlike in the proof beyond reasonable doubt in criminal proceedings, and without the cumbersome cumbersome court procedure. In fact, even the characterization of the offense as crimes against humanity and war crimes will compound the problem, because aggression by its nature is committed at the highest levels of government. Again, witness the defendants in the main Nuremberg trial, witness the defendants in the main Tokyo trial. These were all the big shots. And it is easier to establish, it's easier to identify who is responsible, and easier to establish their culpability by the nature of their office and by the nature of the charges being filed against them. And yet in this case, because the ICC cannot look into the crime of aggression, it is then constrained to investigate more specific crimes against humanity, and war crimes which are more difficult to prove in a proceeding. And so by way of closing, the enforcement, ICL as an enforcement regime carries within
its framework, its own normative preferences. And that is why, at some point, choosing ICL as the enforcement regime is also to choose the kind of justice that we seek to get in a conflict situation, in an atrocity situation. It's not just the kind of justice, but the kind of justice for whom. Are we looking primarily at the victims, or are we looking at some sort of vindication for an international law framework writ large, anchored upon the Article 2, Paragraph 4 prohibition on the use of force written in the UN Charter? So for me, ICL is not just about procedure. It is about, first and foremost, about jurisdiction. And in the end, it is about the kind of justice that we seek. I close on that point, and thank you.
Thank you very much, Judge Pangalangan, for a very detailed examination of the Ukraine-Russia conflict and its international criminal law aspects. We will now be opening the floor for questions. So to our audience, please feel free to send in your questions to Judge Pangalangan in the Q&A chat box. I now invite Professor Michael T. Chu Jr., the International Criminal Law Program Head, to moderate the Q&A segment.
Thank you very much, Anna. And I am happy to dive into the questions. We have quite a number of questions for Judge Pangalangan. Thank you for that wonderful presentation, Judge. Let me start, Judge Pangalangan, with a question that sets this entire discussion in the context of world politics and international relations. That question from a participant asks us whether it will be a factor in how the ICC prosecutor investigates, or if it eventually tries personalities after finding jurisdiction, that we are now talking about a major player in global politics, a major power, relative to all the others who have been tried before in the ICC, and whether that will affect the dynamics of the process, or that the court will be blind to that at all. I suppose this question really asks you, Judge Raul, as a scholar, looking at these institutions from the perspective that you had taken in your presentation. So just to recap, will it affect in any way the dynamics of the process, that we are now talking about a major player or power in international relations?
Well, thank you for the question, Mike. By major player, you're talking about the country, not about the person.
Yes, Judge.
Okay. Oh, yes, of course, Mike, because the last time, or perhaps the first time, the court faced this dilemma was the Afghanistan a pretrial chamber decision, appealed to the appeals chamber eventually, where the prosecutor asked for permission to investigate crimes committed in Afghanistan by basically three groups, by Afghan military personnel, by UN personnel, and by personnel by both the United Kingdom and the United States. So if you recall, Mike, the pretrial chamber initially said, well, sure, we see that all the requirements to proceed with the investigation are satisfied, except that we think there are, under the statute, the language is countervailing interests of justice, about allocation of resources, about this case taking too much of the court's time and energy and resources, and dismissed the case. That was appealed before the appeals chamber, which basically reversed and enabled the prosecutor to move forward. So that confrontation demonstrates for you the difficulty for the court to confront the major players. So yes, Mike, this is one of those situations where the court will handle a case not in some, how should I say this, minor, to use your language, Mike, not in a minor player, but against a major power. So it's been, the court has moved forward with the Afghanistan investigation that will potentially deal with the UK and the United States, and in this case, it is moving forward on the investigation of a case which will most probably deal with Russia. Okay, let me pause at that point.
Thank you, Judge. There is another question before I go into the legalities and questions relating to some of the mechanisms in the Rome Statute. That given the nature of international relations and how interests at play could lead to certain settlements used loosely in this term, what would be the attitude of the courts, either the ICJ or the ICC, when something like that happens? It gets settled out of court, settled again, used loosely, even after it has seized jurisdiction over a matter. So whether you're talking about the ICJ or the ICC, do we see some permissive attitude of the court to just let the parties take the case out of its jurisdiction, or has it usually proceeded with these cases despite supervening events, I would say?
Okay, Mike, 2 points. The tension between peace and justice was recognized at the outset, even during the drafting of the Rome Statute. Because we are all aware that in peace negotiations between two warring camps, saying that even after peace is agreed upon, the leaders of one camp will be hailed to court is not an idea that will promote the signing of those peace agreements, and is not conducive to sustaining that fragile peace. So it is not a new or strange dilemma for the court. But Mike, the fact that the Rome Statute moved forward and the ICC was established also says a lot. It recognizes that if you want a just and lasting peace, that's the formula, a just and lasting peace, you need some form of accountability. So in terms, Mike, of the, you asked about attitudes. The attitude is that we do need these accountability mechanisms. Otherwise, the peace is compromised from the beginning. Okay, but Mike, you were also saying realistically there might be some compromises later on. I imagine, even if, well, by the way, let's face it, there are some crimes that cannot just be compromised. I mean, the attitude of the court, the approach of the court is that, of course, crimes are crimes. That is, that if a crime has been committed and it appears so before the prosecutor, he will file a case, and after trial, if the person is guilty, that the accused will be punished. But if you're asking if in lesser cases the court might be minded to look the other way, I don't think that they will acknowledge or admit that they are doing that. I imagine they will find some nice legal jurisdictional formula to say that we're moving forward on this matter, but not on other. matters. But I don't think we will ever get a frank admission that the court, well, blinked. And I think, again, the best example is the Afghanistan pretrial chamber decision, where the sort of the escape clause, the interests of justice clause invoked by the pretrial chamber was basically roundly set aside by the appeals chamber. So I think, Mike, that decision indicates to you already the stance of the court on that sort of a dilemma.
Thank you, Judge. That was illuminating. Let me proceed, Judge, then to the questions that are of a legal tenor. So one of our participants, also a scholar, has seen so much commentary on Putin and whether he can be prosecuted by the ICC, and most of those commentaries, I assume from this question, would say that he can. But given his status as a head of state of a non-state party, so we can even generalize this to heads of states of non-state parties, the scholar doesn't think that there'd be sound legal basis for the court to exercise jurisdiction over that head of state. So while he enjoys personal immunity under customary international law without a UN Security Council resolution. So really, the scholar is just asking your views on this, whether you agree with much of the commentary or you have thoughts otherwise.
Thank you, Mike. Okay. The question of head of state immunity has been addressed by the appeals chamber of the court, saying that the traditional head of state immunity, and which has become part of customary international law, is immunity before national courts, and that in international criminal law, from the beginning, head of state immunity was never available. So if one wishes to refer to customary international law, there is no custom that gives immunity to heads of state before international tribunals. That was one main point affirmed by the appeals chamber in the al-Bashir case. But having mentioned al-Bashir, you might have seen some commentary before, Mike, that the meandering fate of the arrest of al-Bashir, the non-cooperation of member states in their duty to arrest and surrender an accused person pursuant to a warrant of arrest issued by the court. Some commentators said that after al-Bashir, they doubt if the court will ever venture to issue a warrant of arrest against a sitting head of state, because it lowers the credibility of a court whose orders are not respected. So we do face that. I think that is the dilemma that we face here, and in fact, coupled with the other difficulty that I mentioned earlier about not charging the crime of aggression, then basically we will have to find a mode of liability to attribute the crimes all the way up to Putin, and will it be as a perpetrator under a joint criminal enterprise theory? Will it be by command responsibility? And all those questions, which, by the way, Mike, are basically the same questions we face in the investigation of the ICC of the extrajudicial killings in the Philippines under the war on drugs of President Duterte. So the same issues in the Philippine investigation are relevant to the question that you raise as regards the Ukraine situation.
Thank you, Judge. And I think it's a testament also to your presentation today that this is of the points that you have raised, that we have generated so much interest. We actually have a lot of questions coming in, but I think we only have time for maximum 3 questions.
Okay.
Judge, I will try not to take so much of your time. You've given so much already. But let me ask one question, and I think this is also of particular interest to you, Judge. There is a question on whether the possibility of the same conduct as basis for the prosecution of 2 different separate crimes under the Rome Statute. And I suppose this really calls into question the applicability of the idea of cumulative crimes, I would say, or is that still a doctrine in its infancy? So we're not yet sure whether the same conduct can be the basis for different prosecutions under different designated crimes.
Oh, thank you, Mike. Oh, the ICC has a whole case law on cumulative charging, cumulative convictions, and concurrent service of sentences for those convictions. So, in the last case that I sat in the court, the ongoing case on child soldiers, we had many. There were many charges which overlapped, mainly offenses of sexual offenses. There were forced marriages. There was rape, forced marriage, forced pregnancy. There was the in other words, yes, we have encountered the problem of concurrent charges and overlapping crimes, and there is a case law available to deal with them. But the short answer is yes, it will be possible to charge all of those crimes. They will have to be treated carefully in the nuances.
Thank you, Judge. We are down to our second to the last question. This one is more procedural, I would say, and having sat in a pre-trial chamber, so let's suppose, Judge, that this investigation gets to that stage where the prosecutor is asking the chamber to confirm charges. What type of evidence would a judge sitting in that chamber look at in order to agree to confirming charges that say under crime of aggression or war crimes in this case?
Oh, well, of course, Mike, you're talking about a hypothetical trial for the crime of aggression, because there is no mechanism to do that now. Well, Mike, it'll be basically, for me, the template will be Nuremberg. At some point of the trial, it became a war of documents. In fact, if you read some first-hand accounts, the one account said that the irony was they were dealing with the most heart-wrenching stories, but the evidence was basically, the case buildup was basically boring documents to establish the culpability, the chain of responsibility all the way to the higher-ups. But so if you ask about evidence, there will of course be forensic evidence about the well, I was talking about war crimes and crimes against humanity. You were speaking specifically about the crime of aggression. Then, Mike, I'm just looking at the definition of the crime itself. Mike, I imagine it will involve documents. It will involve even the speeches of issued by Putin, by the foreign minister, to show that there was a decision taken to launch a war of aggression, and which is why I said earlier that it is easier to prove this crime compared to war crimes and crimes against humanity.
Thank you so much, Judge. And now we're down to our last question. And I circle back to your final point on the distinction between the primary rules and secondary rules, and how choosing a mechanism for enforcement affects the norm that is being enforced. And the question then would be, Judge, whether you're seeing a trend in which this this effect on the norm that is being enforced by the choice of mechanism ends up strengthening the norm or its status in our international legal landscape? Or do you see it going somewhere more contested, where the norm would now be open to contestation because of the choice of remedy, and therefore there would be room for argument from many sides that contest the norm and waters it down? What do you think, Judge, is the direction of the norms there in our international legal landscape?
Mike, are you speaking about a specific norm or norms in general?
Just in general, Judge.
Okay. Mike, if you put yourself in the shoes of the prosecutor of the ICC, if he didn't take the measures that he has taken, I think it will be a body blow to the legitimacy of the court. And so for me, sure, he might be taking a risk, but I don't think he had a choice. He had to step into the debate and assert his power to investigate, but also to declare the limits of his investigatory powers. So my short answer is it strengthens the norms by both the ICC and the ICJ moving on these cases. If you read the commentary, for instance, commentaries on the ICJ case, one would the view is that, well, sure, Ukraine was able to score on provisional measures, but can you imagine the decision on the merits on this case? What will that decision say? The same thing for the ICC. Maybe at some point, people will keep on asking what happened to the crime of aggression. Why look at the lesser crimes and the lesser criminals who will then be accused before the court. So what I'm saying, Mike, is yes, there is a risk, but I think there was no choice. The risk had to be taken. Otherwise, the normative framework itself will be weakened.
Thank you very much, Judge Raul. I think that assessment provides, or strengthens the confidence that we have in the normative framework that we have right now and the institutions that enforce the norms there. Thank you very much, Judge Raul. And I apologize to those whose questions we weren't able to ask. We only have time for those number of questions, and I turn it back to Anna.
Thank you very much, Judge Pangalangan and Professor Chu, for participating in today's Q&A. And thank you to our audience for sending in your questions. I would like to invite the audience to answer the customer satisfaction form sent to the chat box. And at this point in the program, may we request our speakers and panelists to kindly turn on their cameras and gather for a quick photo op. And may I also request IPD to spotlight our speakers and panelists for the photo op. Thank you.
Thank you, Anna. But just also to notify our participants, the program is not yet over. We have the launch coming up soon. We're just going to take this photo up now.
May I request IPD to spotlight the panelists and speakers again? Thank you. Okay, big smiles in 3, 2, 1. Thank you very much. I think we got our photo. We now move on to the launch of the International Criminal Law blog of the UP Institute of International Legal Studies. I would like to formally...
I just want to say, Anna, I just want to say thank you to Rommel and Wheeling for inviting me to speak. And thank you also to Tony for being present for the entire panel.
Thank you so much, Judge Raul.
Thank you so much, Judge Raul.
So, now I would like to formally introduce again Professor Michael T. Chu to lead the presentation on the ICL blog. Professor Chu is the head of the International Criminal Law program of the UP Institute of International Legal Studies. He teaches courses on international human rights law, constitutional law, administrative law, and torts and damages. Let us welcome Professor Michael Chu Jr.
Thank you very much, Anna. It is my pleasure to launch the blog of the International Criminal Law program of the UP-IILS today. And it'll be a quick one, I promise. Let me just take you through the features of the blog. So as you can see, we started the International Criminal Law program under the leadership of our director, Romel Cases at the UP-IILS, with the thought of Filipinos and Asians in mind, that we would have a platform for our ideas and commentaries on international law, in particular international criminal law. And so this is a snapshot of the contents of the blog. We will go to the actual blog at the end of this presentation, and let me just stress the objectives of the ICL program, which is really to reintroduce ICL to the Philippine public, which is part as well of the mandate of UP International Institute of International Legal Studies, especially in light of the ICL discourse on the Philippines' membership and withdrawal from the Rome Statute and the possibilities of rejoining moving forward. Also to generate interest, as this is an interesting and independent field of international law that the Philippines had participated in for years, even from its inception. And we want to be able to generate and cultivate new scholarship here as well. And, you know, when you write your papers, it's not a quick process, but if you want ideas to quickly get out there, even while you're writing your longer paper, this is the platform for you to do that. And so you can see that these are the features of the blog. That when you enter the site, we have the blog pieces themselves. In here, so far, we have 2 blogs on the proposed international crime of ecocide, proposed by a panel of experts constituted in 2021. And we also have, of course, a blog on the Philippine situation being investigated at the International Criminal Court. And, you know, going through the responses to that from all sides, and trying to analyze some of the thorny issues that we have in that investigation. The blog also features events on international criminal law and international law in general. And we've had one last year on the analysis of the Pangilinan versus Cayetano decision on the Philippine withdrawal from the Rome Statute regime, as well as last week also dealt with the international criminal law chapter of Judge Raul Pangalangan's book, Philippine Materials in International Law. So that is also featured in our blog. And then, of course, just to go quickly through my photo and but I want to focus on a research team whose photos are also here, and they are students of the UP College of Law and members of our program who are interested in this issue and are doing actual research work, substantive work in this area, and some contact details that we have. So that's really just a quick tour of our blog. Let me show you the actual blog that we have, and I would request one of our research assistants, Nick Munoz, to share that, please, so that our participants can take a look at the actual blog. So you can see the URL of our blog right there. And here is the actual blog that we have. We will be, so be on the lookout for the announcement where we open the blog for submissions. So today we're just launching the blog, and so we don't have that option yet, but that will be available soon. And so while we wait for that, you might as well already be crafting your blog posts on burning ICL issues and international law issues in general with ICL or IHL components, so that we can feature them in our ICL blog at the UPILS. So just some of the items that you actually see on the blog, which I also showed you in the presentation. So that's it, right? So after this event, rather, we are going to post the URL of the blog in another material that you will see online, and you can access the blog and read the 2 blog posts on substantive ICL issues that you find there as of now. Thank you so much, Nick, for navigating the blog for us. We will open submissions again to the public within the next 2 quarters. Thank you so much, and I turn it back to Anna for our closing.
Thank you, Professor Chu, and congratulations to the Institute of International Legal Studies for the launch of its official blog on international criminal law issues. With this event coming to a close, we're honored to have the director of the UP Institute of International Legal Studies, Professor Romel J. Cassis, who will be giving us his closing remarks. Professor Romel Cassis is a co-convener of the AsianSIL ICL interest group. He teaches international environmental law and policy in the LLM program of the University of the Philippines and public international law in the JD program. He also teaches obligations and contracts, torts and damages, and supervised legal research. We now welcome Professor Romel Cassis.
Okay, thank you, Anna. This has been a very fruitful event, very encouraging and insightful afternoon. I thank everyone's active participation. We, of course, thank Judge Pangalangan for gracing us with his presence and his insight. Also, the presence of Professor Anthony Angie and Dr. Chair Ling, also for being here. I think this event and the blog that we just launched today demonstrates the growing importance of international criminal law. How we wish we live in a world where we don't have to define war crimes or crimes against humanity, and that those things do not exist. Unfortunately, we do not live in that kind of a world, and we do need criminal law, international criminal law, to perhaps put a stop to these atrocities. And that is where the ICL interest group and the ICL blog comes in. As Dr. Chow mentioned earlier, the need for a critical debate, and if I may add, a deeper analysis of the issues and legal norms that are involved is absolutely essential for us to forge a path forward, perhaps out of this endless cycle of violence and war that has gripped our world. Again, I thank Judge Raul for his lecture, how he explained to us the strengths and limits of ICL, and it was quite insightful. And although he's now known as a judge, I think Judge Raul today actually showed how he's an academic, a professor. I felt I was back in his classroom listening to him again. So it was a great experience, and I'm glad he didn't call anyone for a recitation today. But it was a great experience, and we also I thank everyone who sent their questions. There were a lot, and unfortunately, we don't have time for them. And I know there are, if we wanted to, we could have continued the discussion much longer, but we can't because of time constraints. However, that's exactly why we have the ICL interest group. We have a Facebook page. We can share our insights, our questions, our frustrations, even our announcements for our future work. And we can, so please join us. If you have an interest in international criminal law, please join AsianSIL and join the interest group. And also, we have the blog. Start writing, start submitting your possible blog posts, and maybe perhaps together we can help strengthen international criminal law. Again, thank you so much for everyone here, and I hope you have a wonderful day ahead of you. Thank you.
Thank you very much, Professor Cassis. I would like to thank again Judge Raul Pangalangan, Dr. Chia, Prof. Tony Angie, and Professor Chu. We now conclude this event. The AsianSIL International Criminal Law Interest Group, the University of the Philippines Institute of International Legal Studies, and the UP College of Law express our sincere thanks to our speakers. Thank you, everyone, for joining us today. Good afternoon.
Thank you very much.
Thanks so
Judge
much,
Raul.
Raul.
Dr. Tony. Thank you, Dr. Chia.